In this video, we'll discuss tort in public education context. The word tort comes from a French word meaning twisted or wrong. A tort is a civil wrong that leads to personal injury or property damage for which the court will provide a remedy in the form of an action for damages. Tort liability refers to liability incurred when a civil wrong against a person is caused by malicious intent or negligence, and the overall disregard for human rights. The principles of tort law are straightforward. When a person causes physical or property injuries, the injured person should be compensated. When someone damages the property of another, the owner of the property should be compensated. The only controversies are the measure of compensation and the types of injuries or damages that should be compensated. Grounds for action in tort can be divided into three categories: intentional interference, strict liability, and negligence. In most education-related civil lawsuits, there are two main categories of tort liability related to professional educators: intentional and negligent tort. We'll briefly talk about intentional torts at the end of this video, but most of this video is about tort of negligence. Tort law in the United States is generally a matter of the state common law. In 1992, the Georgia Tort Claims Act was signed into law. Prior to the act, Georgia citizens were not allowed to sue state agencies or their employees in civil court. The Georgia Tort Claims Act effectively ended the sovereign immunity protection the state had enjoyed against tortuous lawsuits. The Georgia Tort Claims Act is a set of statutes that determine when a government entity may be liable for tortuous conduct under the state law. The act also opened the door for litigation to be brought against the school district and school district personnel. A school district in the state of Georgia is eligible for qualified immunity protection. Here is the case, the McDowell versus Smith case in Georgia. This case was about a 6-year-old student who was abducted from a school by the student's non-custodial father. In 2005, a school receptionist received a phone call and a fax from a woman posing as Smith. The woman instructed the receptionist to release her daughter to a man named L. The receptionist testified that the woman told her to request L's identification when he arrived, and she did so. The receptionist searched for the student information card to determine if L was listed on it, but she was unable to locate the card. The receptionist found the student's classroom by checking her file in the school's computer system, which contained no warning about L. The receptionist called the student's teacher, who sent the student to the office. The student recognized her father and was happy to see him, and the receptionist released the student to him. Later in the day, the student's grandmother called to ask why the child had not been on the school bus, and the receptionist then realized that the fax was a forgery. The student's mother filed a complaint, alleging, among other things, that the receptionist was liable for negligently releasing her daughter to her non-custodial father. The receptionist explained that she did not follow the required procedure because the student card had not been filed alphabetically, and the student had changed the teachers, and the receptionist was unaware of the change. The receptionist testified that she could have gone to an administrator to determine how to handle the situation. However, the principal was out of office and the receptionist did not know where the vice principal was, although the principal testified she was at the school. According to the school's principal, there were written procedures in place at the time of the incident that required that all student information cards be filed alphabetically and that an administrator be consulted before any faxed notes were accepted prior to checking out a student. The receptionist testified that she was not aware of the existence of written procedures until after this incident. McDowell received a letter of reprimand from the school for failing to follow procedures. The appellate court ruled in favor of the student's mother due to the fact that the record shows that as the receptionist, her duty included checking students out of school early. This is significant because it reflects this responsibility as an official duty. School policy required that before releasing a student, she was required to check the student's information card to verify that the person picking up the child was actually authorized to do so. If the person was not listed on the card, the child could not be released and an administrator had to be consulted. The most common tort is the tort of negligence. There are 4 elements. The first element is existence of a duty. Educators and administrators have legal duties to take reasonable steps to protect the children in their charge. In the McDowell case we just discussed, the school receptionist had the duty to check the student's information card to verify that the person picking up the child was actually authorized to do so. The second element of the tort of negligence is breach of the duty. To be liable for a tort, a defendant must fail to fulfill a duty. If you try to provide assistance to the best of your ability, then you do not breach a duty. The third element of the tort of negligence is causation. There are 2 types of causations. The first type is cause-in-fact causation. The breach must have been in the chain of events that lead directly to the injury. Breach of the duty is the cause, otherwise the injury would not happen. Another type of causation is called proximate causation. This is more complex than the cause-in-fact causation. The key is foreseeability. It is about whether the injury should have been foreseeable to the breach at the time of the breach. It is not about whether the injury was actually foreseeable. It is about whether a reasonable person would have foreseen the injury. For example, in the case of Joseph Dedich, a student was injured in the school hallway during an altercation with another student. The 2 students had known each other for years before the altercation, and they had not previously had a verbal or physical dispute with each other or with any other student. Moreover, the altercation, which was brief and unanticipated, occurred spontaneously during a chance meeting between classes. Therefore, teachers or administrators would not have foreseen the injury, and the school is not liable for a tort. The fourth element of the tort of negligence is physical or property damages. Even if the first 3 elements are met, there is no tort of negligence if no injury occurs. After a plaintiff successfully proving all of the 4 negligence elements, the plaintiff still have to overcome any of the defenses to the tort of negligence. In the educational context, 4 defenses are often used. The first defense is contributory or comparative negligence. The plaintiff, who is usually a student or a parent, contribute to or share in the blame for the injury. Adults and children over the age of 14 are presumed capable of negligence because they have the cognitive and psychological intelligence to foresee the legal consequences of particular actions. Therefore, most high school teachers and administrators will have the defense of contributory or comparative negligence available to them when a student alleges negligence. The second commonly used defense to negligence is the defense of assumption of risk. Students make a conscious decision to assume the risk inherent in an activity. Schools and educators usually seek documents called liability waivers or consent before potentially dangerous activities such as athletic competitions and activities off the premise of the school and other situations that could potentially pose a risk beyond what would commonly be expected in an educational setting. The third defense is sovereign immunity. Most schools are in some way a part of state government, and each state is sovereign. This defense protects school systems, such as districts, boards of education, and schools from tort liability, but it does not protect individuals, such as teachers, principals, and superintendents. The fourth defense is statutory immunity. Some states grant immunity to educators. The federal law that provides for statutory immunity is the Paul Coverdell Teacher Protection Act of 2001. The act was named after a Democratic senator from Georgia who introduced the act in the prior Congress. Under the Teacher Protection Act, if teachers and principals follow school rules and acted within the scope of employment responsibilities, they will not be subjected to liability. In addition to tort of negligence, another class of torts is intentional torts. The difference between the intentional torts and the torts of negligence is the intentionality. The intentional torts that apply to the educational context is battery. It is an intentional act that causes harmful or offensive bodily contact. Assault, which is like an attempted battery or a threat of a battery, false imprisonment, and intentional infliction of emotional distress. In this video, I introduced tort liability, the four elements of the tort of negligence, and the four commonly used defenses to negligence.